Welcome to Cuts Adda. As you might be aware, today is National Consumer Rights Day. And to discuss this important issue of consumer rights and consumer protection, we have with us Pradeep Mehta ji, the founder of Cuts.
All right. Thank you very much, Urvashi. And first of all, the significance of December 24th is important in terms of
Yes.
Consumer Protection Act 1986, when it was assented to by the President of India. We have another
Yes.
consumer rights celebration across the world, which is the World Consumer Rights Day on 15th of March. In effect, I would say India has a double-decker bus to celebrate and observe consumer rights. We are far ahead of many other countries. Now, in 1980s, when at the time of Indira Gandhi and then followed by Rajiv Gandhi, we had the 20-point program of the government, where consumer protection was one of the 20-point programs of the government. Now, in order to give it some teeth or put some flesh on the bones, it was during Rajiv Gandhi's time that the Consumer Protection Act was conceptualized, and we were involved in the drafting of the same. Rajiv Gandhi began the first economic reform in the country, I would say, though he's not being given that kind of credit. But he had to go, of course, tread slowly. And then he realized that it is important that if you're going to open the market to competition, it is important to provide better protection of consumers. The consumers will have to face more consumer abuses than what they did when it was mostly the state which was supplying goods and services. Say electricity, telecom, railways, three large state enterprises which are providing important services consumers were consuming on a day-to-day basis. Speak about three positive outcomes and three negative factors. Of course, there are a host of them, but I thought this will tell the viewer exactly as to what the highlights are.
Yes.
Firstly, the paradigm has shifted. The paradigm has evolved. Sorry, used to be caveat emptor, to now it has now become caveat venditor, which is buyers beware to sellers beware. The act has been very effective. Government has put in a lot of publicity to publicize it. Now, not only that, but what is often forgotten is, data is churned out by the government about the kind of complaints which have been resolved by the consumer disputes redressal machinery. What they do not capture in the data is the kind of redressal which consumer groups have been able to provide to consumers by advocacy, by conciliation, by purely, sort of talking. I'll give you an example. We got a compensation for a lady school teacher from Otis Elevator of 50,000 rupees without going to any consumer court, but just by using the threat of the law. As I say that, the stick is, often, the fear of the stick often works far better than the stick itself. And therefore, there are such cases which, as I said, have not been documented. Thirdly, the biggest outcome of this is what is happening on a continuing basis is the improvement in the law. Now we have a new Consumer Protection Act, which was steered by the late Consumer Affairs Minister Ram Vilas Paswan in a very enthusiastic way, which deals with all the changes which are coming about. For example, e-commerce is something new. Not that the law did not cover e-commerce, but in order to clarify any of these issues, financial services, etc., all of which are developing so fast that the new law has been designed in a way that it has to be done. What the new law has also done is to establish a central consumer protection authority, which will deal with misleading advertising and deceptive claims. And the beauty about that law is that it will also hold the endorser liable. If Amitabh Bachchan is modeling for some particular item or good, and if there is something wrong in the good, you can haul Amitabh Bachchan also to the court. They are this sort of, so that there is more responsible advertising. There are three negative factors about the law. One is what has happened over the past is imposition of court fees, which we never had in mind when we drafted the Consumer Protection Act in 1984-85. And the courtization. Most of our consumer courts, intentionally we said we're not going to use the word court because people are scared of going to a court. So you use the Consumer Forum and State Commission and so on. But it has now, the whole machinery has become like another civil court structure. Even Government of India advertised civil consumer courts. When we objected, they said, look, ordinary people don't understand the difference between consumer courts and consumer forum. Fair enough. But that is a big tragedy that has happened. Court fees, etc. The second is the presence of lawyers. What has often happened is the cases are being adjourned irrationally again and again, and because of the presence of lawyers and usually the presiding officer always is a retired judge who has come up from the lawyers' ranks, by and large. And they are used to, scratching each other's back. Okay, you want an adjournment granted. Now this, Urvashi, is in spite of the fact that we put in the law a time period ceiling, but we added the words as far as possible, which is as an exception to the rule. Now what has happened is that has become the rule rather than the exception. And the third issue, which is very important, is again it's a part of the soft law provisions of the Consumer Protection Act, the establishment of the Consumer Protection Councils at the level of the union government, state government, and districts. What are they supposed to do? There are 6 consumer rights which have been recognized by the law. They are supposed to promote and protect those rights. Now, of course, it's mainly these are talk shops, but even these talk shops help quite a lot. The new act, which has come in 2019, has been a result, a consequence of the deliberations which took place in the Central Consumer Protection Council. Now, unfortunately, PASFAN lost interest in the council. So after April 2017, not a single meeting of the Central Consumer Protection Council has taken place. Most, if not all, the state consumer protection councils are dormant. And what to talk about district consumer protection councils? God knows what is happening. Now that is to summarize my 3 bits good news and 3 bits bad news about the act implementation.
Yes, but
as I said, the good news about the consumer protection scenario is that the laws are being improved and tightened rather than being diluted and made useless. This is in spite of business lobby working against it. One of the factors that we have not been able to achieve against the business/lawyers lobby is to get lawyers out of the system. We argued that, look, even family courts and labor courts, lawyers are not allowed. So why do you need them here? But anyway, we could not succeed.
But thank you, Mr. Mehta, for putting things in perspective for all of us.